Hello, everybody, and welcome to today's discussion on privacy, FOI, and legislative responses. My name is Michael Karanikolas. I'm the Executive Director of the UCLA Institute for Technology, Law, and Policy, a new collaboration between the School of Law and the Stanley School of Engineering. We have an excellent panel of privacy and FOI experts to discuss this issue. Alan Butler is the Executive Director and President of the Electronic Privacy Information Center, EPIC, where he's argued privacy and open government cases in the U.S. Court of Appeals for the D.C. Circuit, the Third Circuit, and the Supreme Courts of New Mexico and New Jersey. He's also a graduate of the UCLA School of Law, great school. Courtney Raj is a postdoctoral research fellow at the UCLA Institute of Technology, Law, and Policy, prior to which she spent 7 years as Director of Advocacy and Communications at the Committee to Protect Journalists, and she holds a PhD in International Relations from American University. And Sarah Bruton-Palmer is an associate with Kaplan Cobb LLP. She specializes in business litigation, media and communications law, and appellate matters. And she is also on the board of the Georgia First Amendment Foundation. There's a lot to get into with this topic, and I'm hoping to have a good amount of time for kind of Q&A and audience engagement at the end. So let's dive right in. I was hoping to kick things off by asking Alan, as somebody who has a foot in both the privacy and FOI world, to kind of introduce us to his thoughts on how privacy should be understood in the unique context of public officials.
Sure, and thanks, Michael, and thanks to NFOIC for hosting this important discussion. I just wanted to start with a little bit of background on the context here. This is an issue that comes up frequently in open government practice, both in the state and federal level. And I think one thing that's important to understand at the outset is that these questions, the issue of, to what extent personal information is restricted from disclosure in government records and through government proactive or affirmative disclosures under FOI regimes, is not only a question of statute and rules, again, at the state and federal level, but is ultimately rooted in constitutional principles and specifically the right to informational privacy. And so the rules that have been developed, again, through statute and regulation over the last 4 decades are really derived from that same principle that when the government holds personal information, what they do with it in particular, the contexts in which they disclose it are limited by the constitutional right that undergirds that interest. And so that is factored in, for example, in the Federal Freedom of Information Act rules around Exemption 6 and other related privacy exemptions. And so I think underlies the whole system. When it comes to the distinction drawn between government officials, in particular at different levels of seniority, there is kind of a balance and dividing line there that has been applied in the federal system, where, for example, if you think about just basic identifying information like a person's name, certainly extremely individual personal information like an address or even more sensitive information, I think in most contexts is limited from disclosure absent some very specific reason. But even when it comes to names of government officials in the federal context, they're typically not disclosed in documents unless that official is at a certain degree of seniority. And that really, I think, has to do with the publicness of the role, right? So certain roles are so much in the public sphere that it really doesn't make sense to be withholding that person's name because their name is already out there, right? Obviously, the easiest example is like the President of the United States, but even as you kind of march down the seniority order within different executive agencies, get to the level like the Assistant Attorney General within the Department of Justice division on, pick your division, that very much is a public role, and some of it has to do with, I think, in the federal practice, which roles are subject to confirmation by Congress, for example. If they're a confirmed executive branch position, then that person's already been, their name has been put out there in congressional hearings and they've been vetted by Congress, their name being attached to a government document is not something that is a surprise or would otherwise really be revealing of much. It's known that they were involved in that decision-making process, as opposed to someone who is an employee, right, who merely plays a role in the process, and but for this disclosure in this document may not be known who they are, they might not be traced to them. And the other thing I'll note is that this issue, I think, has come up in particular in the last 10 years with debates and litigation around certain financial disclosure obligations and imposed, again, further down that chain on senior government employees who are not Senate confirmed. So I'll just start with that. And
yeah, I think that that point about the scale between seniority and expectations of privacy is worth pulling out and emphasizing, where the higher up you go, the more there is going to be a public interest around around information that would be personal lower down. I think medical records related to the president or medical information related to the president is an interesting example there, where that's more of a norm than a legal standard. But there's a lot of public interest in questions around like the health records and the health condition of the president, which obviously wouldn't be appropriate for officials lower down. But that is a good example of how public perceptions get shaped. I want to go to Courtney next for introductory remarks on doxing as a modern challenge and how the internet and digital surveillance has changed traditional privacy dynamics and how things are different today.
Thanks so much, Michael. So I'm coming at this from a global perspective because I think that we want to look both nationally at what we've learned from doxing, from freedom of information, but also recognize that that there are global precedents and issues that we should look at as well. So first of all, we live in a fundamentally different communications system today. So most of these laws and the interpretations, by the judiciary reflect a fundamentally different communications platform. The information is networked. That is different than publishing it in a newspaper or having it available in a database. Yes, it may be easy for a local community member to go down to the public records office and get information. It is much different to talk about putting that online in a networked ecosystem, which can then, be shared around the world with, usually it's not about around the world, but with, like-minded organizations or advocacy groups or extremists who want to end up targeting that person either online or taking it offline with, physical threats. And I think that's where I'm coming at this from is for many years, having studied doxing and the release of personal information related to journalists. I mean, part of this is ironic that public officials are seeking to protect themselves and not everyone else, because we know that journalists are in this really interesting position where on the one hand, they love the access to all of this information. They love having personal information easily available. And I've been a journalist myself. It's great being able to figure out, to investigate and figure out, this person was not living where they said they were living, or, the house or car they're driving doesn't seem to comport with their public service salaries. But they've also, journalists are also incredibly targeted by doxing, and it's used as a form of intimidation. We know that regardless of, whether you're a journalist or a public figure, that online harassment and doxing, the release of this personal information, overwhelmingly impacts women, people of color, and marginalized communities, especially when you have any sort of intersectional identity with a marginalized or historically excluded community. And so I think we really have to think about that. Also, this is, that information is not just published. Again, to get back to the fundamentally different platform, it also then becomes data, right? It then becomes, it circulates online. There is a permanency online that is different, a findability, a traceability. And in this country, we don't have a meaningful national privacy legislation the way that, for example, the Global Data Protection Regulation, the GDPR in the EU, which provides basic rights in terms of what information can even be collected in order to be released, and as well prohibits the release of information without explicit permission. And I think that there's this challenge of balancing between wanting to have enough information available out there in order to find the issues around corruption and to improve transparency of public officials, but also recognizing that we don't want to deter people from serving in the public. And we've seen this happen again with women and people of color. A friend of mine is in Congress. We went to grad school together, and she has a terrible experience with online harassment. Why would anyone want to run for public service if it means that your information gets, put online, people start harassing you at your home? And I think, as Alwyn said, there is a fundamental difference between positions that have a, public figure role or, external communications role and an internal communications role. But I think it's also, here we're talking about typically it seems like a certain set of information, but it's not even clear what we mean by doxing. Just a couple of days ago, the organization I used to work for, Committee to Protect Journalists, published an article about a Brazilian journalist who was doxed by a public official who took his picture and posted it online, which then essentially outed him as an investigative journalist and has put him at risk. And they're saying that equates to a death threat. On the other hand, doxing originally was used as a term to reveal anonymizing data. And so the founder of 8chan, for example, says that he was doxed in his real identity release. So I think we also need to get clear about what we mean by doxed, and what information qualifies under there. And it should not just be something for public officials.
Yeah, I think that last point about doxing being in the eye of the beholder is a very important one, especially when we consider, I think, what one of the main themes of this conversation is going to be, which is the impacts of these potential legislative proposals that aim to guard against doxing, and trade-offs inherent in how those protections are structured. And I think that brings us to Sarah, who can introduce the legislative trends that we've been seeing towards both redacting more personal information about public employees from records, as well as new laws passed in Arizona, Colorado, Florida, Kentucky, Minnesota, Oklahoma, Oregon. We don't need to discuss all of those laws, but the general legislative trend that's been going on and why there are concerns about these laws.
Sure. And I think too, the themes that Courtney was hitting on are really important here, which is the varied and contextual meanings of the phrase doxing. It's a bit of a buzzword that can mean different things to different communities in different contexts, but is something that sort of is used a lot in this context as a motivating factor about why we might need these laws, because it just has this, specter of danger that goes along with it, but it means a lot of different things. And it, I think in its original form, more meant the revealing of information about general members of the public as opposed to officials, but that seems to be the area where legislative responses to these issues are focusing is public officials and judges. I think that the situation that with Judge Salas in New Jersey in 2020 was a big motivating factor for a lot of these legislative proposals. And you might remember she was the district court judge there who someone came to her house and shot and killed her son. And in response to that, Daniel's laws have, that was her name of her son, have proliferated across the country and are bubbling up. I believe New Jersey was the first one to pass one, since it was sort of their home state where that happened. And that requires redaction or no public disclosure of personal identifying information of certain public officials and judges. The exact contours of these vary across the different states that are considering them, but it's an open record solution to this problem that legislatures have been coming up with. there are a lot of other solutions that you can use to deal with doxing, whether that's, harassment laws, restraining orders, sort of, more common criminal tools that I think were things that people relied on when this problem started happening originally. But in the open records arena, it has turned out to be shielding information generally about elected officials and not things that would apply to, regular folks. Although we have seen some examples of the implementation of these laws in places like West Virginia have ended up creating such administrative hassles that the agencies who are charged with implementing them have started to apply these things broadly enough to apply to everybody, because, for example, in West Virginia, they passed a law in 2021 based on this Daniels Law framework, and court systems in that state, instead of trying to figure out, well, they found it too burdensome to try to figure out who is a public official and who is a judge and who should have their personal, address and cell phone number shielded under this law. It was just too much of a headache. And so they have decided to shield all that information about every single person in the court system, which creates a lot of reporting problems with criminal defendants, people who have been indicted. If you're trying to figure out even just, is this person who was just indicted the same as this person over here? I can't match up their addresses or any other identifying information. If they have a fairly common name, it can be challenging to figure out, any patterns about people who are involved in the criminal system. And then it obviously comes with a lot of delays that get built into open records frameworks that we have seen that agencies charged with implementing laws like this will either respond by doing these blanket redactions of information where they just lock down a whole category of information that you can no longer get about anybody, or it imposes a huge back-end cost when you request a certain record that it either costs a lot of money to go through all this stuff to find who should be redacted, and it also causes big delays, which are already a huge problem in open records regimes. And so it just ends up burdening the public access to information that is already pretty burdened in this country with the types of legislative solutions that we're seeing here.
So thank you very much for that introduction. I want to get back to the implementation questions a little bit later in the discussion. But for now, I kind of want to open things up by asking about whether new technologies mean that we should revisit this traditional understanding of expectations of privacy for public officials. And this is something that I learned when I first started in this space. Is the more senior you are, the less privacy that you get, and that's just how it is. And if you don't like that, don't go into public service. I mean, that's what happens when you rise high up. Is there's more public interest in what you do, and it is what it is. That's a fundamental aspect of democratic society. So I kind of want to ask all of our panelists whether that principle still holds true, or whether it needs to be revisited in light of, first of all, the changing technologies, as I think Courtney mentioned a little bit, related to the accessibility of information, the network nature of the information, network nature of the audience for that information, and likewise, rising political polarization, political extremism, rising threats against public officials, whatever you want to call it, and whether you think either of those has impacted that principle or should impact that principle, or whether any recalibration is necessary. I kind of want to throw that open. Alan is unmuted, so maybe I'll start with Alan.
I'll jump in on that. I mean, I think there is a rethinking happening in light of the trends that Courtney had mentioned in terms of how quickly and significantly this sort of information can get accessed online, spread online. It's very different than accessing physical paper records. But I think at the moment, at least, we may be overlearning part of that lesson or reacting in an overly narrow way. And what I mean by that is that the traditional model, and almost sort of like a natural pyramid scheme model, is that the folks at the top that hold the most power in our society, and government in particular, are exposed to the light of public scrutiny necessarily in the democratic process. And that is a natural impact of them holding positions of power. And those folks who are just regular citizens living their lives are entitled to more privacy protection. And part of my discomfort with the Daniels Law model is it flips that upside down, and it says actually we should focus all of resources on protecting the privacy of a narrow few who are at legitimate risk, right? There's no question that that what has occurred in terms of the targeting of judges and other officials is reprehensible. But I think the answer is that we need workable, broader protections for everyone, not just protections for a narrow few. And one other example I'll give is that to show that there's a lot of work to be done in this regard, especially at the state FOI level, is a case that we at Epic recently worked on that we believe didn't come out the right way, which was a case out of New Jersey, Boise versus Jersey City. And this was a case about, of all things, dog owner registration records that the state collects as a compulsory matter for all dog owners and essentially makes publicly available to anyone that wants to request it. And in this case, what was being done essentially is they're being requested in bulk by companies that want to sell like dog walking and other commercial services to these people, but they're able to just essentially scrape all these people's names and addresses. And ultimately, the court, the New Jersey Supreme Court, did not essentially find that the current New Jersey FOI rules required the agency there to restrict access to these names and addresses. And that data, once it comes out in one frame, gets fed into these systems and profiles and makes it easier and easier for anyone to get doxxed. And the sorts of problems that Courtney's describing the journalists face are not going to get fixed by a narrow regime like a Daniels law.
I mean, I couldn't agree more with Alan on all of those points. And wow, that's really shocking that companies can just buy these public records in bulk to scrape them. But I think that what this emphasizes is the need to look at privacy laws for everyone, not just, as you said, for a select few. And that this idea of like narrowly tailoring these laws just for some aspect of public officialdom is really missing the broader point that we need a comprehensive approach to how we deal with personal data online, and then how that is able to be used by different types of actors, whether they're commercial or journalists reporting in the public interest, or a general person. And should there be different standards? Because right now in this country, we don't differentiate between who can gain access to public records, as we've seen entire new companies be created, as far as I understand, from the availability of real estate information online. I can tell you from personal experience, as well as from my work with journalists and human rights defenders in the US and around the world, that it has a chilling effect on their willingness to speak publicly or to have any sort of public profile online, or to even enjoy all of the benefits that social media can bring, because there is this underlying concern about doxing. And I, from personal experience, I don't go on a lot of platforms, and I have a lot of separation between my personal and my professional life, because I'm very concerned about doxing. And I think it's very real, especially in this country, the idea that like all of these records are public with your address available. I think that we have to come up with a framework that recognizes the fundamental difference about that being accessible from anywhere, from outside of the community, from that can then be networked, and the levels and types of harassment that are then possible that lead to both the physical threats, but also, we call them online threats, but they can be completely debilitating and prevent you from being able to do your job, from ever getting hired again. So that has to be a realistic concern. And I think that we also need to look at the technology as a potential way of solving some of this problem. I'm very sympathetic to what Sarah was saying about, the costs involved. I worked at Freedom House during the initial like WikiLeaks leak, and there was a FOIA request. We spent, days going through and trying to take out the names of human rights defenders so we wouldn't put them literally in peril. However, can't we figure out how to, as we're modernizing these systems, a way to say tag personal information that would allow us to leverage all of the amazing AI and machine learning that has been developed in the service of the public interest, which is to make as much information available as possible without putting people at risk. And doing that is going to require not just legislative solutions, but also technological solutions so that we can have the possibility of dealing with this vast amount of information in a realistic way.
Yeah, I would definitely agree that technological solutions, I think, are going to have to be a part of the equation, because trying to do this legislatively with existing public records regimes, especially at the state and city level, is just really hard. They don't have the resources. And so coming up with, creative ways on the back end, whether it's, at the point of data collection or, some solution within an office or within a computer system is, I think, the best way to go, and would solve a lot of the problems that we're seeing in implementation of some of these blunter laws.
We talk about technical solutions. As far as legislative solutions go, to what extent is this a problem for a general or comprehensive privacy law or data protection law in combination with existing existing statutes against things like stalking and harassment? To what extent is that a solution, or are these, are those aspects of it not fit for purpose in terms of dealing with the specific technological dimensions that are there?
Yeah, I mean, I think that there's more than two, but there's two significant layers of the problem when we think about doxing and misuse of personal information, and there's a third. And I'll note that already some of the questions queued up kind of get to the point of what about the underlying unlawful behavior. I mean, in many cases of doxing and harassment and threats, the behavior is already prohibited, and yet it still happens. So that is not sufficient, I don't think. I think that we have the level of the intake and output by the government itself, either state or federal, and then the level of aggregation, dissemination, and access given by third-party private sector brokers and vendors. And so far in the US, the comprehensive privacy proposals and regimes that we've seen rolled out in the last 5 years, and at the state level in California, Colorado, and elsewhere, and the proposals at the federal level, specifically the ADPPA, and currently pending in Congress, does not get to government, does not reach government collections and uses and disseminations. None of those regimes do directly, unlike the GDPR, which does also apply to government entities. So it can address the privacy regimes we've seen and are proposed and rolling out in the US can begin to address that second level, I think, most effectively if they impose substantive restrictions on what types it can be collected and the circumstances in which it can be used or disclosed, and actually put strict limits on the companies that are large in scale and are contributing to the systems that are used in some of these bad situations, like the major brokers and people search engines. If they are required to kind of comply with a more restrictive regime in terms of when they can give access to that information, then I think that would start to get to the problem. But we also have to address the problem at the legal and resource level for government agencies.
So I want to push back slightly on the point that because the laws as they currently exist are not stopping particular behaviors, that means the laws are inadequate. Because you can have a great law, but if police are not implementing it properly, or if police are not prioritizing adequately complaints around stalking and online harassment, which they're notorious and I don't have a comprehensive knowledge. I'm still a relative newcomer to the US, so I don't have a comprehensive knowledge of jurisdictions down here. But certainly in Canada, police are not good at responding to like these newfangled electronic stalking type, harassment type crimes and complaints. And they're not good at dealing with domestic violence. I'll go out on a limb and say that's probably true here as well. It's quite often we see a problem like this manifest where police are failing to use the tools that they have in order to deal with it, either because of a lack of training or a lack of prioritization or a different incentive structure, whatever it is. And then there's a rush to pass new legislation to give new powers to police and new powers to lock people up and new kinds of protections, while ignoring the fact that adequate protections are already in place. Is that something that might apply to this circumstance? Sorry, I should direct this out. Courtney, is that something that might apply to this circumstance?
Yes, to a certain degree, absolutely. There is a lack of enforcement of existing laws, and for a long time, and still in some places, you see law enforcement view online as somehow different from real life, which of course we all know is not accurate. I think that there's a real challenge to getting law enforcement to understand threats and what incitement means. I think is potentially different online, because it can become, again, the networked effects and what it does in the absence of any sort of privacy law or ability to, retroactively get information offline. The other thing that we see in Europe is you have a national privacy data protection law. You also have the so-called right to be forgotten or the right to be delisted. And that gets back to the fact that, there is a better recognition in Europe that this communications platform is fundamentally different. And so, if you go to here, if we talk about getting doxxed, or whether, even if it's not an incitement to violence, if you're doxxed, that information is then out there, it can be easily weaponized in the future because there's no ability to ever remove it. The way that also, First Amendment jurisprudence is interpreted here is very absolutist in terms of what is seen as expression, and very much in the eyes of the, or in the voice of the person expressing versus how that impacts other people's ability to express themselves in the future. And so I think, we really have to look at this comprehensively. Without the right to be forgotten, that information can be out there forever and easily accessible and then put into new databases, et cetera. And again, if we think about the difference in the technology here, the ability to create entirely new industries and, economic, businesses basically based on the use of all of this very personal data is something that we have allowed without a meaningful public conversation about what sort of oversight there should be, whether there should be any hoops to jump through before you can do that. We should remember Clearview AI, right? They went through all of these public social media profiles and scraped that information and then created databases, digital imagery that can then use AI to algorithmically identify and use facial recognition in public spaces, which reduces privacy. And I think we don't have laws or enforcement that are fit for purpose to make use, to deal with those use scenarios, because what is public and private information in the networked digital age, when we have really sophisticated machine learning that can then do things with that data that is fundamentally different than in the past. And, there is this link, I'm seeing in the comments, questions around kind of government versus private sector. I think what we're seeing a lot of these days is private sector doing things because there are no restrictions on the type of information that can be gathered and shared and aggregated and sold, and then law enforcement or government agencies buying access to that. So doing a runaround, the typical requirements that might be in place in order to gain access to that information. So that's also something we want to think about. And I raised that because, again, when we're talking about doxing, we're not clear on what does that mean. Intimate images are a huge form of, doxing, but that's usually treated in a separate framework. But I think, again, we need to really figure out, what do we mean by public information? How do we protect privacy in the digital age? And what does this mean for public accountability in government, where, transparency is really important for accountability and democratic governance?
Sarah,
Yeah, I just want to jump in on some of the how the First Amendment operates in the US. And I do think that's just a value judgment that we've made as a country that I don't think is going to change realistically. How the First Amendment treats statements by members of the public in terms of a right to be forgotten. And I also think that we at least assert to have a high value in transparency here. And so working within those frameworks, I think it's important to come up with solutions that both, recognize the fundamental First Amendment values that exist here, and also shore up the transparency values that we have, while coming up with, whether it's regulations on private companies and what they are allowed to do with this information once it is out there, while maintaining a robust regime that allows access from the public and journalists to the information that they need to do their jobs and scrutinize things. It just seems like, there are other ways to do a lot of the things that public records laws are trying to do to fix a problem that I don't think is really going to be fixed by a lot of the legislative solutions we're seeing. And I did also want to address the Uniform Law Commission attempt at this. I thought it pop up in some of the comments. That's an organization, if you aren't aware, that comes up with model legislation that states put a lot of value in, and sometimes they can sail through legislatures because the commission has put their stamp on it. This is typically more done for topics where uniformity among the states is important, like serving a subpoena across state lines from a state court case. It makes a lot of sense to have uniform rules for that. They're currently coming up with a uniform law to deal with redaction of private information of public officials. And there's a lot of problems with that and some of the implementation stuff that I've talked through. But really, I think a lot of these, issues with local and state open record systems and just, community values in terms of, do we think property records should be open to the public here? LA County does not, Atlanta does. I can imagine why LA County doesn't necessarily want to put, Brad Pitt's property records up online. But if you live in Atlanta, it's very easy to find out who owns what house and where. Those decisions are a lot easier and better made at the local and state level, where people understand the limitations of the computer systems that we have. And, is your state really rural? Is your state really urban? What are the values of you, having particular types of information open there? There's just a lot of problems that would flow from a uniform law on this stuff that are really hard to foresee from a national perspective, as opposed to folks on the ground.
Yeah, there's a lot of really interesting questions in the chat. We'll get to them in just a second, but I just want to ask one more first, which is, just picking up on this idea that these laws are leading to overzealous implementation or overzealous redactions, right? That this is getting past the local officials and they're saying that it's like, all right, we'll just not release anything. So if you're telling us that that we have to redact names, there's so many names and this stuff, it's way too much work. We're just going to give you a blanket refusal and take us to court, I guess. We're done. That is, as somebody who works on freedom of information here in the US and around the world, that's a very familiar story. And to me, that's not necessarily an argument against these laws. It's not an argument in favor of those laws either, but that's an argument in favor of greater oversight and enforcement over the freedom of information system, right? The remedy to that, that's something that I don't think is unique to these laws. I think that is a symptom of a freedom of information structure that lacks appropriate enforcement, right? And the solution to that is, well, my solution is you institute an independent administrative oversight body, because that's what's done in Canada and it works not to say it works well, but it works better than it works down here. You don't force people to go to court. But without, turning this into a whole debate about oversight bodies, is that the issue here? Is this a broader oversight issue, or is this something specific to these laws that lend them to abuse? And maybe I'll start with Sarah, because
yeah, I would absolutely love to have independent oversight and of both the federal and state regimes of open records laws, because I think there's just a huge problem there. There's so many barriers to effective enforcement of these laws, and you have to have a really big problem that's worth bringing a case in court, or a lot of resources. And there are just regular folks who every day get told by agencies across the country, sorry, that's going to cost $5,000 up front, or it's going to take us 6 months to do this. And it just becomes prohibitive. And so, in Georgia, we have a lot of problems like that. We could use very much an independent board. But color me skeptical. I don't think that's going to happen. And so if you're in that world, I think talking about the implementation problems that flow from these laws is valid and is a good argument against them, because nobody really seems to have much interest in forming some independent administrative solution to these issues. And I also think that the type of information that these laws are targeted against is just stuff that appears everywhere, all different agencies, all different records. And so the scope of the problem that's created in implementation is big enough to warrant some real consideration as you're implementing this stuff.
Michael, let me raise one other, kind of interesting point about this is the more information that you put behind, say, a FOIA request, or that you redact and have to somehow gain access to, that also poses risks, right? I think most people probably, hopefully, heard that there was a reporter who was killed in Las Vegas by a public official following his investigations of that public official. So directly related to his reporting. If reporters or other investigation bodies need to go through public records requests, that's a big red flag for what information you're looking for. And so there's also an interest in being able to get information without having to flag to the authorities that you're requesting that information from, oh, I want all this information on these police officers, that's going to be a big red flag that could then end up putting the requester at risk. And so there is this trade-off as well between allowing, about putting more information behind, redaction or request formats, and the ability then to do investigations that are often in the public interest, revealing corruption or malfeasance or misuse of public funds, and whether there would be a deterring effect if more of that was put behind redaction.
So moving on to the questions in the chat, I want to start with this one because it's got a good opening. I wish we were hearing more pushback on Courtney's arguments from the other panelists. If government officials get to take this and use this kind of information for whatever their own purposes, there's no reason the public shouldn't have access to it. Just because people misuse information isn't a reason to deprive their people of it. So I imagine there's probably agreement on that last point at the panel, that you can't necessarily calibrate laws based on people doing bad things with information, although I guess it is a relevant factor, the degree to which information lends itself to particular harmful uses. But the core question there is, what's the difference between the government collecting this information and that information being made publicly available?
I mean, at this point, very little, right? I mean, as I mentioned before, you see law enforcement buying databases and access to data, and not just law enforcement, but all sorts of government actors buying access to these third-party databases and information. So I don't think that there's a big difference there.
But I guess, so there's two ways to understand that. On the one hand, you can put restrictions on government from collecting or surveilling particular types of information, right? But allow the private sector can do it. But allow the private sector to do what it wants to greater leeway, right? And the argument for that is like, well, it's more harmful when government does it because government surveillance is more nefarious and yada, yada, yada. And the answer to that, as you just mentioned, Courtney, is, well, if you allow the private sector to do it, but you prohibit the government to do it, the government will just buy that information from the private sector, and then the government's going to do it anyway, right? I think that what this question is asking is the other way around, where the government is collecting information, right, but is redacting it from being publicly available, right? So what is the harm to preventing public access to databases of personal? What is the harm related to public access to databases of personal information that the government has?
I mean, I think that I would maybe it's not exactly flipping that around, but I would note that, I mean, in general, whether you're talking about government or private sector use, when we're looking at modernizing the privacy regime in the United States to catch up to what Europe and other countries are doing, what we're really trying to do is we're trying to make sure that personal information is really only being collected and used where it's necessary to avoid the unnecessary exposure of individuals to all varieties of harms, including the ones we're focused on today, doxing and abuse, right? So yes, in the private sector, there are all sorts of things people may want to do with personal information, including your address, name, financial information, et cetera. But the law generally, in some ways, not adequately, I think, has recognized that we don't allow people to do all of those things with personal information and collect it or use it for those reasons. The same is true of government. So and should be, right, normatively, we need to improve the rules around collecting and using personal information, both for government entities and for the private sector. But there are all sorts of, when you drill down to individual examples, there are all sorts of situations where there is a legitimate reason for collecting and using personal information narrowly by the government that would not be legitimate in the private sector. And I'll just take one that has come up in litigation recently that may spark interest or not, or disagreement, but it is donor information, which is generally able to be kept confidential, but in some circumstances has to be disclosed for tax purposes by a nonprofit to regulators, including the IRS and or the state regulators. So there's been a dispute in California over a state level requirement that entities provide copies of the schedules that they would normally file with the IRS to the state attorney general for like a broader set of enforcement uses, and concern that the California Attorney General's office has had breaches in the past and doesn't necessarily have an immediate use of that information. So there, even between state and federal government, there's debate over whether it's necessary actually for the state attorney general to have copies of all of those sensitive records that the IRS has a legitimate purpose to use, but clearly those records are protected from disclosure at the federal and state level. We recognize that they're not just supposed to be generally available to the public. So there's lines drawn in a bunch of different cases in either direction.
I think you could also look at, again, like we haven't really defined what counts as doxing, but let's think also about forms where you have put on your gender identity, for example. And then, you might have a reason to do that, on a government form related to, let's not say it's a protected HIPAA type thing, or say you're on an app, your HIV status, your gender identity, your sexual preferences, that really has no protection, privacy protection anymore. And yet that can lead to outing, which is a form of doxing. And I think the other thing is, again, it can be, all of that data is not just sitting there as an individual piece of data. It is being fed into very sophisticated systems that are learning things that are then, we don't actually know what they're learning about and how that is then going to be used in predictive settings, whether that's predictive policing or in judicial decisions or in selling product or not selling product. So I think we have to realize that like the type of personal information, we really need to understand what is going to be covered by there, because there's also, I think it's very gendered in terms of what we think about as private information. I mean, there was a question in the chat about kind of public versus private spaces. And I think, again, with the rise of very small surveillance technology, pervasive surveillance technology and shifts in expectations of privacy in public places. Like what is under my skirt or up my blouse should be private, even if I'm in a public space, right? Is your intimate interaction as a non-public figure with somebody in a park, is that really a public information that should be put online, and again can lead to really challenging outcomes? And so I think we have to have a better understanding and consideration also, if we're going to pursue greater privacy protections, we need to do that in a more comprehensive way. So it also includes information that is overwhelmingly personal and used to target women.
So we have another question in the Q&A from Megan Ryan. A committee of the Uniform Law Committee is working on a model to remove home addresses of all addresses, judges and law enforcement personnel for government databases. Thoughts on this, particularly as it relates to property records? So I'll jump in with one of what I see as a completely legitimate use of that information, which is, I think it's enormously relevant to know the proportion of police that are living in the neighborhoods that they're policing, right? One of the things that we hear quite a lot about in terms of challenges related to either police violence or police accountability is you have police in large cities that are living in the suburbs and don't live in the jurisdictions, and it creates a disconnect between the actual the people walking the beat and the actual communities being policed. So that's one thing that immediately jumps to mind of why that might be an interesting thing or a relevant thing to look up. But I'll throw that to the panel about their thoughts related to that model rule.
Well, I've already given my negative take on it, but I'll add another potential use of that information as respect to police officers. I was talking earlier about, criminal defendants or people who get arrested, making sure they're the same person. But there's also, if an officer is fired from one jurisdiction, hired in another, and they have a very common name, you can use things like address information to make sure that that is the same person, and double check that the story you're writing to say that this person just got rehired over in this other suburb, that's actually the same person, and that can be a pretty useful back end check for that kind of information. But I think this problem suffers from a lot of the same issues that we've been identifying in terms of the protection for those at the top as opposed to everybody else, when those folks are the people that might be the topic of journalism and are worthy of public scrutiny, and could shut down some real legitimate avenues of reporting.
So there was another question that was just posted by CSPRA. And I think it echoes something that I wanted to raise previously, because I think that came up in the letter that Sarah was involved in drafting regarding the proposals. The comment notes that hiding information that is inherently public does not accomplish privacy or security. And so one point that I've heard made related to these laws is that if the information is accessible elsewhere, you're not really achieving anything by creating this additional level of secrecy. And the lack of efficacy of these laws and actually obscuring that information is an argument against their implementation. Are there thoughts on that?
I don't think that is supported by the evidence. The more barriers you put up to gaining information, the fewer people are going to be interested in doing that. So, for example, in this country, it's very easy. You can literally Google someone's name and up pops all of their previous addresses. The data brokers and the access to data is unparalleled in this country as compared to literally anywhere else. If you put up a barrier, so you have to pay for it, that makes it a little bit less easy, or you don't make that available and you have to actually do a lot more digging, where maybe you have to either go in person to a place, or you have to go to the individual website of that entity versus just Googling somebody's name. We can make it harder, and that will absolutely have improved security impacts on people, especially again women and marginalized communities who are overwhelmingly impacted by this, but also I think to the public officials, the judges, the people who are, the target of protection in these laws, because again, most people probably aren't going to take the time and do the sleuthing, right? And so the people who are, then we can maybe address intent more specifically in that. And then looking at if you're posting that information with the intention of doxing, then that can become something that you can look at. But you adding barriers so that anybody who Googles a name can't just get your entire, social network address history, phone numbers, et cetera, should absolutely lead to an increased level of security. It's not going to be perfect, but it will raise some barriers that will improve the safety and security of people on the ground.
Yeah, I mean, I think one issue is that the proposals that are coming out, the Daniels Law related proposals are both kind of overly broad and overly narrow in a way, right? I mean, they're narrow in the sense that they only target certain government systems when that information is already available in a bunch of private sector systems. But they could be overly broadly applied in those systems to shut down access to a whole bunch of other information. And then also they're overly narrow and they only focus on this narrow subset of already powerful government officials who themselves might be legitimate subject of journalism and don't protect the rest of the folks that also need protection from doxing, like the journalists or like ordinary people who can be doxed as well. So I think that really it's an overly narrow way of trying to get at a much broader but important problem, which is, I think, limiting or putting real meaningful restrictions at scale on the way that this sort of information can be collected and used. And it doesn't mean it can, I think the ultimate rule that needs to be implemented is not that, something like address information can never be accessed and used, just that it can't be an absolute free for all like it feels like it is right now.
Yeah, there's another point. There's another comment in the Whova chat by Kurt Brennerman that I want to pull out because I think it illustrates an important duality here, where he notes that it's important not to base access to information on the intention of the person requesting the record, right? That, again, I learned that as a cardinal principle of the right to information, because if you open the door to that and you allow officials when a person makes a request to say, well, why do you want it? You get all kinds of shenanigans where, they can start to learn like, oh, you're working on an expose on corruption in my office. Interesting, that's good to know. Or, you allow them to differentiate and say like, well, I don't think you have a good reason for this information, so I'm not going to give it to you. That's very common in right to information laws around the world, and it's uniformly abused. It's a giant red flag when you see that in the law, is any kind of opening the door to questioning about people's uses. However, when you see these, the proposals that have been passed related to posting information or sharing information in a way that promotes stalking or creates imminent and reasonable fear of harm. I'm phrasing it wrong, but they use the proper Supreme Court standard. Intentionality is a key part of that, right? Because you don't want to say like, well, because initially it's just something somebody else put in the chat, which is, you don't want to have a situation where somebody innocuously posts some personal information about a person without that intent. Somebody else takes that information and does something terrible with it. Well, you don't want to trace the harm back to the person who innocuously posted it, because the intentionality, the malign intent is important there. So I don't know if there's, I don't know if that duality is relevant. I don't know if there's specifically attention there. I don't know if anybody wants to comment on the relative challenges related to assessing intent behind where information is either shared or accessed.
I mean, I think one of the problems is that a lot of the issues raised is that it's that intent may or may not be relevant. So in an individual case of stalking or harassment, that might be relevant. But if we're talking about the general availability of records, you might, again, like create a database, like online white pages, right? They're not intending probably to facilitate harassment or doxing, but that is the end result of the creation of that service. So I don't know that, I mean, maybe that's like a very, a significant part of it, but it's certainly not sufficient. And again, I think we really have to think about what is the information that is considered personal. Like, and it's really hard. You think about business addresses, right? So if you're thinking about government, I mean, those businesses should already be public where they are. So that should be easy to find. Whether you need to have that next to the person's name, and again, to just make it that much easier, I don't know. Again, you have the Capital Gazette, for example, somebody tracked down the address of the reporters that they didn't like there and went and killed, 4 media workers there. So it can have real impact. You don't know, in that case, it's an individual intent, but if he had gotten that information through the online white pages, does that mean the white pages are responsible? And just, another thing to your point about misuse of these laws, like it's interesting because I think it was in Poland or Hungary that, or Lithuania, anyways, the government there sued a reporter for putting somebody on the Forbes top richest persons list and said, that's an invasion of data privacy. So these, restrictions are also really susceptible to abuse. And we don't want to have laws that, criminalize the publication of personal information and then have that used against the media, the news media, which you do see a lot. On the other hand, you also see, for example, One News America, ONA, doxed a reporter putting out their address on their Twitter account, and that led to threats against that reporter at her home. So, it's really hard, I think, to design a law that is isn't susceptible to misuse and abuse, but also gets at the core issues that you're trying to prevent, which is, voter intimidation of public officials, dissuasion from wanting to hold any sort of public office or work for government. But again, why is this only for that narrow slice of types of people?
All right, we are just about at time, so we are going to have to leave it there. But Courtney, Alan, and Sarah, thank you for this very illuminating discussion. I'm sure we're going to be hearing more about these issues going forward. So thanks very much, and thanks to NFOIC for this opportunity. Enjoy the rest of the conference.